नाम की लड़की कौन है?
Good evening, everyone.
Good evening, ma'am.
Good evening. My cordial welcome to all for this workshop. My name is
Yes,
Niveda,
ma'am.
Assistant Professor of Civil Engineering Department, Galgotias College of Engineering and Technology. So today webinar is about innovation, IPR and patent protection, presented by Ms. Renu Bala ma'am, Senior Patent Associate, ACES Rana & Co. So first I would like to invite our Honorable HOD sir for speak about our workshop. Sir, it's over to you.
Thank you, Naveda. First of all, I want to thank the Honorable Management who gives us the opportunity to conduct this workshop. Our worthy directors are Dr. Brijesh Singh, who have always been a motivating and support for all of us. Special thanks to Dr. Rajni Garg, you can say, with whose efforts this event would be possible. And lastly, I want to heartily thank from core of my heart to Miss Renu ma'am, Senior Patent Associate, who have spared her valuable time from his very busy schedule, from her very busy schedule to give this, you can say, workshop or to give this talk. As we are always keen to be, you can say, put some patents and for IPRs, but due to the lack of knowledge, we cannot, you can say, we do not, you can say, make it as it could be. So I think from this workshop, we all will be get knowledge. You can say, actually, you can say, comes the dream of the patent to be true. Thanks, ma'am, for sparing the time and giving us this valuable knowledge. I hope this workshop will be very knowledgeable to all of you. Thank you, ma'am.
Thank you, sir, for wonderful beginning. So I would like to introduce our presenter, Ms. Renu Bala ma'am. She is a registered Indian patent agent. She has completed MSc Hons in chemistry and LLB. So having the experience of over 9 years in the field of intellectual property rights. So with proficiency in all aspects of patents, she is successfully able to work on searching, drafting, national and international filing, and also office action response and opinions related to the patents in various domains, especially in chemistry, life science, mechanical. Am I audible now?
Yes, ma'am. Audible?
Okay. So office actions, response and opinions related to patent in various domains, written statements and replies for pre-grant and post-grant and related matters. So now I would like to request ma'am to share your valuable knowledge for us. It's our pleasure to have such kind of the expertized person for this workshop. Thank you, ma'am.
Thank you so much, Nevada and sir, for giving me opportunity to connect to you guys. And it's my pleasure to uh, give you a little bit glimpse of patents. And I would be happy if you would be able to, connect to the patents and just know the importance of patents. And let me because it's very important uh, that you whatever intellectual property rights you own, you commercialize it and then get a lot of out of it. uh, let us start with this directly to our slide. Let me share it and then we'll start. um, just a moment, please give me a moment. Let me share the I think it is it visible to everyone?
Yes, ma'am. It's
Yes,
visible.
ma'am.
Yeah. So just today, let me give you an introduction to what is innovation, what is IPR, and patent protection. So although our major focus will be on patents, but before starting the patent and patent protection, let me give you a small glimpse of what actually is IPR. So IPR basically is intellectual property, the property which arises out of human intellect. So basically which is not in a physical form, which is intangible, but which are capable of use, sale and license. So there are different types of IPR which you can commercialize, and they are very beneficial to you. So first one is the copyright. Patents, I think most of you know about copyright. So just uh, very briefly, IPR includes copyright, patents, trademark, trade secret, plant varieties, geographical indications, designs, domain name. So a little bit of introduction to everyone. We start with the copyright. So I think there is a so everyone knows what a copyright is. Copyright basically includes expression of an idea. So it is not actually an idea itself. It is the way you express your idea is becomes a copyright. For example, the literature, the books you write, any published material, printed material, or the cinematography, uh, uh, all the movies, they all come under copyright. Then comes the trademark. So what if you see, you go and buy some article, maybe grocery or something, this article belongs to a particular company. So any article is recognized by some mark, which includes a device, a brand, a heading, a label, a ticket, name, signature, word, letter, and so, for example, MACD, Orange, Nike. So some mark or some name is connected to that product. So basically, what trademarks is, it identifies the source or origin of goods or services. Basically, whosoever person is selling those items to you, there is a mark which distinguish goods or services of one company from those of their competitors. So basically, it also is associated to the its quality. For example, from looking at the brand that, oh, this might have a very good quality because this belongs to, for example, Adidas. So it also helps in advertising and creating brand loyalty. So that what is trademarks is. What patent is basically, it's an exclusive ownership right granted to owner of an invention. Basically, invention that is an advancement of technology. The science students, basically, they know what is a scientific innovation. They have devised some product or a process, or a new way of doing something, so that basically have to offer a new technical solution to an existing problem. So that what this protection is about. Then next is a design. So you must have seen various designs, bottles or configurations, or which you see in the market when you buy any Coca-Cola bottle or Pepsi bottle. They have different configurations from each other. You can, from your eye, you can distinguish between two different bottles belong, which are available in market. So basically, what a design is, an industrial design is something which is applied to an article by any industrial process, and the finished article basically appeals to the eye. So this design, such type of design can be protected separately. So we can have a separate protection for IPR in such cases. So then there is a geographical indication. So a geographical indication is a sign used on the products that have a specific geographical origin. You must have heard of Nagpur orange, or Darjeeling tea, Kanchipuram silk, Kulu shawl, etc. So all these uh, products, they have certain reputation because they belong to a particular region. For example, from India, then these are given separate protection, which is called as a geographical indication. Uh, Similarly, protection is also provided to plant variety. So it also gives legal protection to a breeder in the form of plant breeders' rights. So these are intellectual property rights that gives exclusive rights to the breeder of a registered variety. So when you see a product in the market, so there are separate IPRs which are available to, or which a product covers on IP. For instance, when you see the Horlicks bottle, there are different aspects to it. First is why you buy Horlicks, because you have to drink that formula, which has some advanced formula, which has more miscibility in the milk, or which have more nutritional value. So all these formula, they are protected by basically the patents, because this is a novel formula. And the industrial design, when you see there is a certain configuration, so of this bottle, so it is of a very beautiful design. Maybe it has a specific configuration to it, so that is protected by industrial design. And then the artistic work basically is covered under the copyright. And the Horlicks, you can see the logo, and logo, it is covered under trademark. So basically, one product it requires more than one IPR also. And all these IPR in totality, they provide a better protection to some article or a product or a process which can be commercialized, and you can get value addition out of it. You can, you can get benefit out of it. I'll just give you one example. For example, even if Coca-Cola stops manufacturing its, unit, it closes its factories, it stop manufacturing things, still that the brand name Coca-Cola itself is worth million. So you understand the, strength of IP. So it is a intangible asset, but it has a very high value. Even if all the physical, uh, uh, physical form, means plant and machinery goes away, everything goes away, but still the only that brand name will, you may sell in billions, of dollars. So that is the strength of IP basically. So so we now, uh, required to discuss about what are patents, because we are here to discuss patents in details. So what exactly is patent? So as I've already discussed, that a patent is a exclusive ownership right granted to owner of an invention. So we'll discuss what invention is uh, in details in the, subsequent slides. So basically a patent is granted for a term of 20 years. So what exactly patent holder can do? Patent holder can prevent others from manufacturing, using or marketing the invention without consent. Basically speaking, the owner of a patent can stop others from manufacturing, offering for sale, selling, exporting, uh, all these or manufacturing all these process or product which he has obtained patent for. Without his consent, he has to take a license, or he has to, get assignment from for that patent. So without his consent, nobody can copy that product or manufacture or sell it. So now what exactly a patent is? Section 2J of the Indian Patent Act says that invention, what is an invention? Because this is very important. Invention क्या होती है? Invention is a new product or a process involving an inventive step and capable of industrial application. So there are three conditions of patentability of any invention, whatever invention you make. Number one, it should be new, it should be inventive, it should be capable of industrial manufacture and industrial application. So first of all, what do you mean by new? Being novel. Novel means the absolute novelty, means the invention should be a unique or novel device, method, composition, or a process. So basically you can say that it might be either a product or a process. So invention should have a inventive step and utility. So it should be commercially utilized and used. So novelty, speaking of novelty, means uh, it should not be published anywhere or India before, before, and it should not be in public prior art knowledge or prior public use. It should not be claimed in any other specification. So basically publish and perish or patent and prosper. So what exactly this quote means is that I must give you an example, that when you make some new innovation or you come across something new, so that is not available throughout the world. So the absolute novelty is there of that process or whatever product you have made. Now you publish it without registering it. So now what you are doing, you are destroying its novelty. Without publication, you are destroying its novelty. So then thereafter it does not remain, patentable anymore. Normally in India, I've seen many of the, researchers and scientists, they just, if they make some innovation, what they do, they just publish in some paper. So that is good, but it is important that before publishing that innovation or that new increment of the knowledge or new technology, you must go and register for a patent. If you do not register and it gets published, then it is not a subject of patentability anymore. So that that invention cannot be patented thereafter. So publication kills any invention. You won't be able to register that patent, because it would first reach in public domain, then novelty is destroyed. So this condition has to be taken care of very carefully. Number 2 is the inventive step. What is inventive step? Basically, it is technical advance as compared to the existing knowledge. Now, in a layman language, you can say that, for example, you have devised a product, and you uh, have given it some more features which are not obvious. Basically, suppose you have you have devised a new fan, using some new technology, using water and spray and all. And this is um, this it should not be obvious as compared to the prior art. For example, you are not combining anything from the prior art to give a new substance, so that novelty will not be of any use if it is obvious. So any invention which is novel and obvious is not patentable. So you have to see that by combining two or more article, you are not going it should not be obvious to a person skilled in the art. That is a important aspect of the obviousness. For example, suppose you have one paper A, and you go through paper B, and then you combine their readings and you publish a paper C. Just take an example of some innovation. Now that C would be obvious in when you read both paper A and B. So that is the thing, that you should not combine two different things to reach another patent or innovation. A plus B should not be equal to only C. A plus B should be equal to C plus something more. So that what is called as an innovation. I think I am able to make you understand. Otherwise, you may ask, and after the end of this presentation. Then the next is, invention must be of utility. So it should be capable of being made or used in an industry, and it should be useful. It should have a useful purpose. It should not be against the morality. That we will study what are non-patentable inventions, because that is also very important. When you devise something new, you have to see these three conditions, that is novelty, obviousness, and utility, and also the inventions which are not patentable. So these two things basically you have to take into consideration. So, example of patents there. So there are few examples I've provided here. For example, the Lifebuoy color changing protection hand wash. This unique formula changes color as you lather, and when it turns green, you are ready to rinse. So you must have seen this ad in TV commercial. That this Lifebuoy liquid hand wash have a unique, a patented ingredient, that is active natural shield, ensuring that the hands are clean and protected against the germs. This formula is proven to remove 99.9% of germs in just 10 seconds. So basically, this is a color changing. So the moment the color is changed, you assume that all the germs have been dead. So that is so here the Lifebuoy have filed a patent for this new novel formula, that is a color changing formula. So that is an example of a patent. Then the next is, for example, this pest control aerosol sprayer. So this is a new technology. They have devised some new device, and they have taken a patent over this product. It's not necessary that whatever you innovate should be very much of high at very high end models or products or processes. There are some grassroots patents also filed in India, which actually they are filed or they basically emerge out of need at village levels, or what if very basic invention, you can say. For example, the NIF has applied a patent in the innovator's name for this portable energy efficient wood stove. Sorry. And there is a multi tree climber. This is again, this patent has been application has been filed by NIF again in the innovator's name. Then there are electric paint brushes which NIF has applied again. And then there is stencil cutting device for hand embroidery. And India's unique wound dressing that stops bleeding in minutes, that is also a type of patent. So this is a product patent. Then Bangalore engineers make eco-friendly bricks using sludge from polluted lakes. So these are also kind of patents. So these all are innovations. So it doesn't need to be of very high investment, you can say. It can be at grassroots level also. Then there is another patent, for example, process of conversion of waste plastic to produce hydrocarbon oils. So, for example, this is produced by pyrolysis, a thermochemical decomposition of organic material at elevated temperature in absence of oxygen. So, this result that you can see here is a ultra clean, ultra low sulfur fuel. So this is a composition patent. Then a team of students led by R. Vasundevan of this engineering college TCE have invented a technology to obtain plastic tar for road construction. So that this also is a type of patent. Then a lot of people have filed patents for conversion of the wastes into useful materials, like this one, for example, this patented processed they are able to raise the value addition to oyster shell and reduce the pollution made by it. These shells are processed and converted into calcium supplement tablets. So this seashells are also converted into synthetic materials which may be used for construction of bone replacement parts, dental implants, biocompatible prosthetic interfaces, and other structures and devices for implantation in a person or animal. So basically, there are few innovation which are of great value, which converts wastes into useful materials, even commercially viable materials which are of high commercial importance. So these are also example of patents. So now question comes, why obtaining a patent? So first of all, it avoids duplication of research. For example, there are multiple person doing research on the same topic, same subject, and same thing. So while you are uh, patents, what is so patents publication, they will give you an idea what is exactly going on right now, how how paced we are, where have we reached in research and development. So this avoids duplication of research. So it keeps abreast with latest development in different fields of technology. All these literature, patent literature, is a very useful tool. It helps industry to improve existing technology to produce cheaper and better product. It serves as an indicator of achievement in R&D institutions and ability of individual researcher. Helps to frame business strategy according to new trend of technology. Basically, nowadays a lot of institutions are filing a lot of patents. So you, as you are also a prestigious institution, so how important are patents for an institution. So this is a list of top 5 applicants from scientific research and development organization. So here you can see that CSIR files maximum patents. So they have filed in 2019, then Cell Institute, Defense, DRDO Institute, IISc Bangalore, and ICAR. So these are top 5 applicants who file patents. Then academic institutions and university who file maximum patents is IITs, Chandigarh University, MIT University, SRM, Shulini University. So they all file a lot of patents every year. So this is, I think, the strategies of last year. And now, why we file patent and what do we get out of it? The answer is a lot of university, they create a lot of revenue uh, by from licensing of patents and their commercialization. They're assigning to different people who can commercialize, who can manufacture it, for example. So here you can see from licensing only how much revenue, total license revenue from selected patent or associated product licenses they have generated. So Northwestern University, from one this drug, anti-epileptic drug, have generated this much $1.3 billion revenue. So similarly, these all are $1 billion, 719 million. So these all universities, they have generated a huge amount of revenue by just licensing deals. And this IPR monetization, for example, by IITs. So this, you can see, so this data is up to 2018. So this is the total revenue generated in crores by Indian institutes of technology. So for example, you can see here IIT Madras, 29.69 so far crores uh, so they have done monetization in the form of licenses or selling. So this is technology transfer. So this amount of revenue has been already generated by IITs. So now we already have discussed that uh, there are 3 conditions of patentability. Number 1 is novelty. The patent should be, the innovation should be novel. Number 2, it should be non-obvious. Number 3, it should have commercial utilization. Now, it should not come under the purview of non-patentable subject matter as well. So what actually, when you go, when you're thinking of some innovation, or you have something in your mind, you have an idea, or you're developing something, then you have to take care that it should, besides being novel or non-obvious and commercial utilization, it should not be fall under the purview of non-patentable subject matter. So what exactly the non-patentable subject matter are? Number 1, so this is section 3 of the Indian Patent Act, says that an invention which is frivolous or which claims anything obviously contrary to well established natural laws. For example, if someone says that there is a machine which gives 100% performance, or without consuming any fuel, so that perpetual machine is a frivolous invention, because that is against the natural laws. So that is, so frivolous inventions, they are not patentable. Second is an invention, the primary or intended use or commercial exploitation of which could be contrary to public order or morality. Basically, anything against public order or morality is not patentable, or which causes any serious prejudice to human, animal, or plant life or health, or to the environment. um so there are few things. For example, a poison, you cannot take a patent on a poison. Or for example, you might have seen there are various method of cloning humans or animals. So this also cannot be patented. A device for housebreaking, adulteration of food, and, nothing of this sort can be patented. Then a mere discovery of scientific principle, uh, sorry so a mere discovery of a scientific principle, uh, or an abstract theory, discovery of any living thing or non-living things, occurring in nature, they are also not patentable. So if you have discovered some new animal or a plant, or you have, there is a abstract theory, so nothing can be patentable under the Indian law. Then section 3D, this section is also very important. Normally objections that come in FERs, or objections to many inventions, this is a very general type of objections that comes along. So it says that the mere discovery of a new form of a known substance which does not result in enhancement of the known efficacy of that substance, or a mere discovery of any new property or any new use of a known substance, or a mere use of a known process, machine, or apparatus, unless such known process results in a new product or employs at least one new reactant. In a very simple language, let me tell you, for example, you have given a new you have added a new feature to anything, for example to a product. Now this is not enhancing a property, or this is already known, or uh, or it is not giving any new technical feature to it, so it cannot be patented. For Also, if suppose you know a drug, and you now come across that, okay, crocin, it can also be used to treat cancer, for example. It's just an assumption. So a new use of a known substance, or a new property of a known substance, uh, you have some instrument with you, you find out that you can use it for some other purpose. So these kind of new uses are not patentable. Then mere admixture resulting in aggregation of properties, it is also not for example, you mix one thing with other, and then you say that I have devised a new material by mixing two materials working independently. Such type of material or composition is also not patentable, which are just formed by mixing up of two ingredients. Then a mere rearrangement or arrangement or duplication of known devices, each functioning independently of one another in a known way. So for example, you have attached a fan with an umbrella, or you have fixed a torch with a bucket. uh, Such type of just rearrangement or arrangement of devices which are already known, it is also not patentable. Similarly, method of agriculture or horticulture is also not known, so not patentable. Although there are plant breeder right, plant variety act, under which they can be protected. So then another is the any method of treatment. Basically, it is not a method of treatment or method of diagnostic or any therapeutic treatment of human beings or animals to render them free of disease or increase their economic value. It is also not patentable. Basically, method of treatment is not patentable. Also, plants and animals in whole or any part thereof, other than the microorganisms, but including seeds, varieties, and species, and essentially the biological process for production or propagation of plants and animals. Basically, you can say that plants and animals in whole or any part, they are not patentable. Only the microorganisms may be patented. uh, so so these were all the non patentable. So first step is to what identify that to find out that your invention is novel, inventive, and is of commercial utility. And then after confirming that it doesn't come under the non patentable subject matter, you may then proceed further after ascertaining this, that yes. So so one thing more is left, that a mathematical or business method or a computer program per se also cannot be patented. So similarly, a literary, artistic, or dramatical or musical work, it can be copyrighted, so it is not a subject of patent matter. So or presentation of information, method of doing business, uh, topography of integrated circuits, these all are non-patentable subject matter, including traditional knowledge. So traditional knowledge is also not. So this is all section 3 of the Indian Patent Act. You will find all these sections while ascertaining that whether your invention is patentable or not. So this is section 3 of the Indian Patent Act. You can just Google it and you can get all these sections there. So then comes after ascertaining, so we come to patent filing. So now we proceed to patent searching and filing. So now how how you get a protection in patents. There are few steps to it. So we have discussed so far that we have developed a new concept and we have ascertained that it is novel, inventive, and it doesn't come under the you know preview of non-patentable inventions. Now, as for ascertaining the novelty and inventive step of the invention, so we normally conduct a patent search. So patent search can be conducted to know what is the prior art in the same technical domain. Now, what is the definition of prior art? Basically, a prior art is an information that is available in public domain, patented or non-patented, prior to effective date of patent application. Basically, the first filing date is the effective date of any patent application anywhere in the world. So while ascertaining the novelty of an invention, we have to see absolute novelty. Absolute means which is not known, published, or patented anywhere in the world, not only in India but in the entire world also. So what is the source of prior arts? Basically, it's a patent applications which are published, or the granted patents which are granted patents, or the website. There are presentations, there are pictures, there are products available in market which are already in use. There are journals, articles, conference papers. So whatever is published or whatever is visible, it is in public domain, that comes under prior arts of any, for any technical domain. So so basically, to ascertain the prior what are the prior arts, there you can take assistance of any attorney to they who can search for you on the paid databases, or you can yourself scroll through various unpaid databases. For example, there is a database when you Google Indian Patent Office, then you come across ipindia.nic.in. So there are few databases which are free, on which you can search and find out what patents are available in in these free websites. So unpaid databases includes the Indian Patent Office, which is the INPAS, the WIPO patent scope. This is an international platform, so it is World Intellectual Property Organization. So you will get WIPO IP portal, so you can search from this this website. Then USPTO, that is for uh, US Patent Office. You can also search in this free database which is provided by the USPTO. And then there is a European Patent Office free database, that is eSpaceNet. You can also search for patents and other patents basically on eSpaceNet. Then Google Patent. So so Google Patent is a very commonly available search engine. So this is a very good search engine also. Then there are free other databases which are available for free, and you can search over it. So you will then research articles and journals. So this you can also search on the websites and their journal portals. So So these are all unpaid databases. So if you have some idea in your mind and you are going to commercialize something, so you can also yourself go and search over these free databases. Or and if you find something closer to your domain, then you should also go for the paid databases, because before going to invest money in any particular patent or patent innovation. So this is I have included an example of Indian Patent Office, how to search on the Indian Patent Office website. So basically this is a link, this is a IP address, that is www.ipindia.nic.in. When you type it, uh, then you are directed to this page, which is you can see this IP India website. You will be directed to IP India website commercial. So that portal will, there will be a tab which is patents under public search. This will be under public search. So when you click on this patents, you will be directed to another page, which will look like this. That is an in pass for by the Intellectual Property India. So there will be different tabs. This is for patent search, this is for e-register, this is for granted patents. Basically this is application status. The application number, you can just click on the application status, and you can just enter the application number, and you will come to know what is the exact status of that patent application. If it is published, then you will get the published documents as well. Whatever the applicant has filed, you will find under the application status tab. Then so after, this is for publish. When you click here, this is for published, and when you click here, this is for granted patents. Now you don't so there are a lot of drop downs on that page, which you can select and enter some keyword maybe, for example, some word from complete specification, or the title, or abstract. If you have the application number, you can search for it, or publication number, or you have an applicant name, country, address, filing office. So you can, there are a number of search fields which you can select from the drop down menu, and you can search for the particular patents or application which you want to search. Basically after analyzing, and after ascertaining that your invention is novel and inventive, then you can go ahead and go for drafting this patent application. So basically patent application or a patent drafting requires experts, a legal experts help, uh, because this is a technical legal documents. So there are certain parts of which have to be carefully drafted. The most important part is the claims. So first let me go through the what exactly is a patent draft. A patent is a statutory right for invention granted for a limited period of time in exchange of full disclosure of his invention. So basically that draft should contain the entire disclosure of his invention, uh, and method of working, the complete enabling disclosure. Basically that disclosure should give the entire details. If there is a composition, then it's the element, the percentage of the various components. Or if it is a process, then how to achieve that process, with all the process parameters, the percentage of each and every component. So and examples along with it. So basically this entire, in exchange of this entire disclosure, the
Hello. Ma'am, your voice is not coming now. I think there might be some issue. All the participants, please wait.
Sorry for the inconvenience. There is some network issue. The speaker will join. Wait for 2 minutes. We uploaded a feedback link into the chat box. Please fill the feedback form.
All the participants, please wait for 2 to 3 minutes.
Hello. Am I
Yes,
audible?
ma'am. Yes, ma'am.
I'm so sorry. I don't know what happened. It just got disconnected automatically. So just give me a moment to share uh, the slide again. Okay. Is it visible? Hello.
Yes, ma'am. Yes, ma'am.
Okay, so I think we were when I disconnected. I think we started mentioning about patent drafting. So should I continue from that, or something is missed? I just can go back. Hello.
Yes, ma'am. You continue.
Okay, thank you. Right. So basically, I was discussing that there are two things when we have a innovation in our mind, that we are certain that is a novel, inventive, and it has commercial utility, and it doesn't fall under the non-patentable subject matter. After ascertaining and doing all search on free or paid databases, then the next task comes to draft the application. So basically, an application is a techno-legal document, which the most important part of that is the claims. But this is how we structure the document. So as to have, these are the mandatory fields. Basically, it should have a title. It should also define the field of invention, the broader field to which it belongs. Then you have to discuss the briefly the background of the invention and the problem faced by the prior art technologies of the same domain. Then the objective, we have to define what is the object of our invention, the summary, that is a brief synopsis, detailed description which should contain all the examples, the detailed description of the invention, the examples, and everything, like the working of invention and all details about invention. If it is a process, and all the process parameters. If it is a product, then all the features and components of it. And if it's a process, it has a parameter, then example, it should be supported by examples also. And the most important part is the statement of claims. And of course, abstract and drawings are also important, mandatory fields while drafting a patent application. So when I say that the claims are the most important part of any patent draft, I mean to say that the claims basically define our legal protection. So it has to be drafted with utmost care. The claims should be very clear and distinct, and it should clearly distinguish our novel and inventive features as compared to the existing art. So a claim also have three different features. So it should first start with some preamble. For example, a composition, a pharmaceutical composition, or for example, any composition, a concrete composition. So it should, the preamble should give a little bit of the broader prior art or broader technology. And then there is a transitional phase Transitional phase includes the terms wherein, comprising of, including, and then the body actually contains the novel and inventive features of that invention, which we are sorting, we want to have claims on. So this is the body which includes are the novel part of the invention. So while drafting claim, we just understand that we have to carefully give the novel features of our invention in the body itself, and make sure that all the novel features are duly claimed in the independent claim. So just simply speaking, that claim is the legal protection we are seeking. Anything which is not claimed is deemed to be disclaimed. So anything, we won't get anything which we don't claim. So that's why a claim has to be very importantly drafted, and the claim has to be supported by the description. Whatever you are claiming should be a part of the description also. So that is a main thing. So claims basically defines the scope of rights. If the invention is an improvement on a product or a process existing in the prior art, the invention should be distinguished very carefully by characterizing the claim with respect to the prior art. So if it is a very small, it's not important that the invention should be, entirely new. It must contain some novel few features also. And when few features are there, then it can be characterized uh, by, after putting characterized by. So the novel features should follow the term characterized by, indicating that there are few increments to the existing technology. So the most important claim, there are two category of claims. One is the independent claim, which is also the principal claim. Then there are dependent claims, which are definitely important, but they are depend on the independent claim. So their novelty depends on the novelty of the independent claim. So the independent claim is the main claim, that is the principal claim, that should be carefully drafted. So now then there are few types of applications when you go for filing an application. So there are few types of application under which you can file your invention. For example, now you are an Indian applicant, so you will file an ordinary application. Basically, it is a first application. First application might be a provisional application or a complete application. So let me tell you why you file a provisional application. Suppose you have some invention in your mind, it is not under final stages. You need to do some further, work on it. You have to finalize it. It is not under, for example, if you are developing a prototype, or you are developing a new product, your prototype is not complete, you have something in your mind. Now just to avoid that it fell in the public domain by, by verbal knowledge, or some other person is also working on that, so he might come up with the similar prototype earlier than then you will lose your chance, to get rights over that. So in such cases, when you are just an idea, you are developing it and it is not finalized, any process of product, then what you do, you just first take a priority date. So you block a priority date by filing a provisional application. So after provisional application, you have 1 year to file a complete application over that. So if you have some idea in your mind which is, good enough that you can work on it, but which is not, completely finalized, you go and first block a priority date by filing a provisional application. Provisional application should contain a broader, perspective. So the complete application basically should be a narrow down approach of that provisional application. So you file an ordinary provisional application within 12 months, you also go for a, complete application. Ordinary provisional application doesn't require claims, it just needs a brief description a broader description. Then within 12 months, you can file a complete application along with claims. So this is a concept of ordinary application. So normally the first when there is no priority of any application, it comes under the ordinary application. Then what is a convention application? Basically, convention application is any application which has some priority date. For example, I have filed one application in India, and similar application I want to file in US, or EP or something. So first I'll do, I file a ordinary application in India, and within 12 months I can enter other countries within 12 months under PC Paris Convention Treaty, and all the countries party to that treaty, you can file a convention application within 12 months in all those countries. So basically, convention application has some application which is coming from other country within 12 months. Application is called a convention application. Then uh, uh, then what is a PCT application? Basically, PCT application is is an international application. Basically, for example, if you file an application with the World Intellectual Property Organization, WIPO, that is an international platform. So what exactly is the purpose of PCT? For example, you have filed an Indian application in India, and then you need more time to think, like which foreign countries, because convention route will give you 12 months to think and file abroad. Now if you file an international application, it will give you an additional 18 months to decide and to file in other countries. So how do you do this? For example, I am giving an example. You file an application in India, then within 12 months you file a PCT national phase application. Now after filing PCT application, you will get another 18 months, so that you can file in foreign countries in total of 31 months from the date of priority. So it will give additional time to you to think and enter for an application. So basically PCT PCT will give PCT international application is a filing platform which is provided to you under a PCT convention, to file foreign applications under extended time period. Then is a patent of addition. So basically, you can also file. So you have filed a patent already. You are applicant of a patent. You have some device, some addition to your earlier existing patent. Then you can also file a patent of addition. Divisional application is like when you have one or more invention in, but you have filed an application which contains two inventions. Now the controller says that your particular patent application has two inventions, so you cannot be granted two invention in a single application. You have to divide it into two, and you then now claim your two inventions separately. In that case, we file a divisional application. So I've already told what is a PCT international application. So these are the kind of applications, convention, PCT. Then where do you file an application? So that will depend on your jurisdiction. For example, when application is filed by an institute, so all the inventors are from any state. It depends on the jurisdiction of the applicant. So if for Mumbai jurisdiction, so anyone can file an application in Mumbai jurisdiction if he's or the applicant or the inventor is a resident of the applicant is a resident of Gujarat, Maharashtra, Madhya Pradesh, Goa, Chhattisgarh, Union Territory of Daman Diu. So similarly, all those applicants who belong to Haryana, Himachal Pradesh, Jammu Kashmir, Punjab, Rajasthan, UP, Uttarakhand, National Capital, NCT, and Union Territory of Chandigarh, so they can file their application in Delhi. So basically, there are 4 patent offices, and the jurisdiction of the particular application depends on the the state of his residence or place of business. After filing an application, then comes the patent prosecution. So basically, patent prosecution. Now we have already discussed about search, filing. Now after filing an application, so you file an application in your in jurisdiction, which is depending on your residence or a place of business. Now after once you file an application, now 18 months is a locking period for any application. So an application filed under normal course, it does not get published within 18 months. Within 18 months it's a locking period. After 18 months it gets published. But if you file a request for early publication, in that case the application gets published within 1 month of the request for filing early publication. So that's how it can be. So once the application is published, the application comes into public domain. So you can find the documents of all the published application on the Indian Patent Office website. So after this publication, all the documents filed with the patent office which the applicant files is then available on the public domain. So means the website which is ipindia.nic.in. So after publication, now from the date of publication till the date of grant, anybody who has a problem, any person interested basically who thinks that this patent ought not to be granted, so he can come and file a pre-grant opposition against the grant of the patent. So pre-grant opposition, after you file a pre-grant opposition, then the patent prosecution gets delayed. So then if an applicant gets a notice from the Indian Patent Office that this pre-grant opposition has been considered by the controller, then you have to file a reply to that within 3 months from the date of notice given by the controller. And then after considering your reply, the controller will either grant or reject the application. But before that, he will give you a chance of hearing if the application is refused. So after this, if this might happen, this might not happen, your patent application may not be opposed, and directly its examination, then independent of the opposition, if you file a request for examination within 48 months, then your patent application would be examined by the controller. If you do not file request for examination within 48 months from the date of filing, then your application would be regarded as deemed to be withdrawn. So basically you'll have to file a request for examination within 48 months. No application gets examined if you don't file an examination request. So after you file an examination request, so the patent office will issue you a first examination report. So you will have to reply to that examination report within 6 months, or you can get a 3 months extension if you pay a fee extension pay for extension fee. So after either 9 months or 6 months under normal course, your application is either granted or rejected. But anyways, after FER, if the controller is not satisfied, he will give you a chance of hearing, and then you can go for hearing and submit your written response, and accordingly the patent application will be either granted or rejected. Now even after grant, any person in the same technology field, he can actually oppose your granted patent within 1 year. So you have so any person who is affected by the grant of that application may file a post grant opposition against your patent, and accordingly you have to file a reply and hearing, just like the pre grant opposition. and accordingly your application patent will be either maintained or revoked, depending on the decision of the controller. Uh, in any case, after grant of the application, the applicant has to pay renewal fee. So basically, renewal fee start from the third year, but you have to pay after its grant within 3 months of the date of grant. So when your patent get granted, for example, it gets granted after 5 years, then you'll have to pay annuity starting from third year to sixth year after within 3 months from the date of grant. So that is how renewal is being done. And this renewal, the patent has to be maintained for 20 years, which is its term. Patent is active for total 20 years from the date of its priority. Basically, the date of filing, first filing se leke, it's your term of patent will be 20 years. So we have discussed the publication and the request for examination, right? So okay, so now basically, uh, what granted patent confers upon the patentee. The patented product gives the exclusive right to prevent third parties from act of making, using, offering for sale, selling, or importing for those purposes that product in India. Okay, in India. So okay, and basically, patent is a negative right. So why it is called negative right? Because it it stops others for making, using, offering for sale, or selling or importing any product which you have obtained product on patent on. And for any patented process, so basically patents are being filed for both a product or a process or both. So for in case of a patented process, it has an exclusive right to prevent third parties from the act of using that process, and from the act of using, offering for sale, selling, or importing for those processes purposes the product obtained directly by process in India. So so this is the section 48 of the Indian Patent Act, which gives the rights to the patentees. Then after grant, every patentee and every licensee has to file a working statement within 6 months, every year within 6 months from the commercial, end of the financial year, that is March. So every year the patentee has to give information to the patent office whether that patentee's invention has worked or not, and what is the quantum of his work. I mean to say, how much product he has sold. It has worked or not means he has sold his commercial, he has commercialized it or not, and if not, then what is the reason, and what steps he is taking for towards commercializing of his product. So that's, this working statement is mandatory to be filed every year by each and every patented patentee of a granted patent. So that is mandatory till the, till your patent is in force. Okay, so that's so we've already discussed what is a post grant opposition. And even after expiry of 1 year, so any person, if any patent is active, any person, if he thinks that that the patent ought to be revoked, then he may file a revocation application, revocation petition, uh, and in a appellate board, uh, or in a high court against any counterclaim. Similarly, the patentee also can file a suit of infringement against any person who is infringing his products. So this is all about the patent procedures and grants. Thank you. So I think I would stop sharing. Right. So any questions? Hello? Hello?
Yes, ma'am.
Hello. Yes, ma'am. You are on.
Hello. Hi.
If anyone has any question, raise your hand. We will unmute you. And those who are watching it over YouTube, drop your question in chat section.
Hello.
Finish.
Ask.
Hello. Am I audible?
Ma'am,
Yes.
Dr. Rajnikar asking, is there any age or qualification requirement for filling a patent?
No. There is no age requirement for filing a patent. So all is required is a good innovation, which is novel and inventive. And since you have to go through your institute, so your institute's permission. Hello.
Yes, ma'am. Yes, ma'am.
Yeah.
Any attendee have any question? They ask. I unmute him.
Yes, please. I think I can see one participant.
Ma'am, I have one query.
Yes, please.
Ma'am, you have told that there are two types of patents. One is you can say patent. One is applicable after 18 months, and one is we can file within 1 month. So, is there any financial, you can say, obligations or financial difference between these two also?
Yes, sir. For normal publication, you do not have to pay separately. But for, if you want something to be expedited, for example, expedited publication, it will have official fee to it. Yes. So there will be
Okay,
fee difference basically.
there will be fee difference.
Yes,
And
sir.
what else is the difference? So suppose if I want that for certain purpose, I want that my 2 or 3 patents will be published within a 1 month or within 2 months. Means I
Mhm.
need it on urgent basis. Then
Mhm.
means is there any policy is different or all the things are same? Just the time gap is or the time difference is there.
So basically, this is a very simple thing to understand that when you are filing a application, so normally, sir, what happens is that 18 months till 18 months, the application is blocked. So it will not be published or in any case. So this is a mandatory criteria that the patent office will get it logged till 18 months of so after 18 months it will get published. But if you have some urgency, you want that patent to be published as soon as possible, then what happens, what we can do is that we file a request for expedited early publication. So that we will file on form 9 of the Indian of the Patent Act. And after filing that form 9, the application will get published within a month. So most probably sometimes it gets published within 14 days. So that depends, like you want your application to be published as soon as possible. The effect of publication will be that the after publication all the documents will be available on the Indian patent office website. Sometimes the investors ask, or if somebody wants for the tech that it ought to be published, and all the details should come on the patent office website, then in that case you if you need it, then early publication request can be filed, sir. Otherwise it gets locked till 18 months. Nobody will know unless it gets published.
Basically, one thing more, ma'am.
Yes,
Is
sir.
this publication, publishing and granting is same? Means
No,
I
sir.
have
No,
heard
sir.
that your patent is granted. Means publishing and granting is one of the same thing.
No, sir. There are two. See, there are the first publication. The first publication is that you have filed an application. It's blocked for 18 months. After 18 months, it comes into public domain. So it gets published in a journal which says that your application is published now, and after publication, now if you have filed a request for examination, then it will go further for examination. If controller is satisfied that the invention is novel and patented, he will grant you a patent, and a certificate to that effect will be issued to you. Publication, and then thereafter there will be a grant publication also in journal saying that your application is published under section 43, which says that now your patent has granted. So there are two types of publication. First publication is under section 11 is the just that you have filed an application and all the documents are visible in public domain. That is a publication that is separate from that of publication under section 43, which is a grant publication basically. So two things are different, sir.
Means there are three processes. First is filing, and then the patent office will publish it, and then
Yes, sir.
finally we will grant the patent.
Yes, sir. Publish it, then there will be examination. Examination clear हो जाती है, then there will be a grant.
तो मैम जो फाइलिंग करते हैं means all the you can say patents which we file. So is it guarantee that all of them will publish, or there will be some scrutinizing from that?
No, sir. All application scrutinization होती है. If your application is relevant for defense purposes, उस केस में वो publish नहीं होता है, क्योंकि सबसे पहले जब आप application file करते हो, then it gets scrutinized that whether it doesn't, it is not relevant for the defense purposes. If it is relevant to defense purposes, तो वो application publish नहीं होती है. It is under secrecy direction. That is a separate section for which you want a approval from the DRDO. So that is entirely a different, फिर वो वहां पे अटक जाती है कि आपकी defense purposes सिर्फ उसी केस में अटकते हैं, otherwise तो हर application publish होती है.
Right. Thank you, ma'am. Thanks a lot.
Thank you, sir. Any other question?
Rishu?
Yes, ma'am.
Okay. Continue.
Yeah, okay. I think there is no any more question.
Fine.
I hope you all find this session informative, and I hope it will help you in your future. Now it's my pleasure to present vote of thanks. I, Rishu Ranjan, on the behalf of entire ACES society, want to thank Ms. Renu Bala ma'am for giving us such a valuable information, which is establishing nowadays as a need of hour. Also, I want to thank Director Sir, HOD Sir, and Coordinator, who all given us their precious time and encouraged us with their valuable words. Now, lastly, I would like to thank all the ACES club members who helped in making this event successful, and my lovely audience. Thanks to all, and have a wonderful day.
Thank you, Rishu. And then thanks to Renu Bala ma'am. It's
Thank you
such
so
a
much. I hope,
informative session, ma'am. Yes,
thank you so
ma'am.
much.
Thank you, ma'am. Thank you for this valuable knowledge. You share us the valuable knowledge. This session was very informative. Thank you, ma'am.
Thanks.
Thank you
I
so much.
hope you enjoyed.
Yes, ma'am. Yes, ma'am. Very informative session. Okay, thank you, ACES members, for wonderful coordination.
Thank you, ma'am.
Thank you, Renu ma'am. Personally, from my side also for sparing the time. Thanks, Dr. Rajnigarh from Riyadh Bara University, who gave us the contact of Renu ma'am, so that we may able to hear such a wonderful and nice informative session. Thank you.
So it was my pleasure too. Thank you so much. And thanks, Rajni, for giving me opportunity to connect to you.
Thank you, ma'am.
Thank you. All the feedback link is shared to all of you. The certificate will be issued on the basis of the feedback. Thank you.
Thank you, HOD sir, for organizing this such a wonderful event. Thank you so much, sir. So the meeting will be ended. You can read.
Rishu, end the meeting because you are organizer.